Good evening, distinguished guests, faculty members, students, and friends of UNSW Law and Justice. Before we begin, I would like to acknowledge the Bidjigal people, the traditional custodians of the land on which we gather today. I pay my respects to elders past and present and recognise the enduring connection of Aboriginal and Torres Strait Islander peoples to country. My name is Bushra Shahimi, and I'm honoured to have been invited by the Dean, Professor Andrew Lynch, to deliver the welcome for this year's Hal Wootten Lecture. As a final year law student, it's been a privilege to contribute to Diverse Women in Law, an organisation that is proudly supported by this year's esteemed speaker, the Honourable Justice Dina Yehia, as its patron. Diverse Women in Law's mission, which is to champion diversity and inclusion in the law, is one I'm very proud to support, and it's especially meaningful to be part of this evening's celebration of legacy and leadership. The Hal Wootten Lecture was established in 2006 by the faculty in honour of our founding dean, and it has become a highlight of our academic year. The lecture commemorates Hal Wooten's founding vision for the faculty, that a law school should have and communicate a key concern for those on whom the law bears harshly. We are especially pleased to welcome members of Hal's family this evening, including Professor Gillian Cowlishaw, Hal's wife, Hal's son, Richard Wooten, and Richard's granddaughter, Caitlin Wooten. Our speaker tonight, the Honourable Justice Dina Yehia, is a proud UNSW alumna, having graduated with a Bachelor of Arts and Law, followed by a Master's in International Criminal Law from the University of Sydney. Since her admission as a solicitor in 1989, Justice Yehia has dedicated her career to advancing justice and equity, beginning with her work at the Western Aboriginal Legal Service. She later served as a solicitor advocate with the Legal Aid Commission and was called to the bar in 1999, becoming a public defender and taking silk in 2009. She then became the first female Deputy Senior Public Defender in 2013. Her honours notable cases include murder trials and the 2009 terrorism trial at Parramatta. In 2013, she appeared as lead counsel in the High Court case of the Queen against Bugmy and in the special leave application in Honeysett. Appointed a judge of the District Court in 2014, she chaired Diverse Women in Law from 2019 to 2022, mentoring women of diverse backgrounds in the legal profession. She currently chairs the Nugra Yura Committee and serves both on the Bugmy Bar Book Committee and the board of the Australian Institute of Judicial Administration. On 23 June 2022, Justice Yehia was appointed a Justice of the Supreme Court of New South Wales and was sworn in on 4 July. In 2022, she returned to UNSW Law and Justice as an adjunct professor, where she teaches a newly developed sentencing course. Her book, The Essential Guide to Sentencing in New South Wales, was published in December 2023. Please join me in warmly welcoming the Honourable Justice Dina Yehia.
Thank you very much for that very kind introduction and welcome, Bushra. I've had the advantage of getting to know Bushra through Diverse Women in Law, and she is a very impressive young woman. I also thank Andrew Lynch and the faculty for asking me to give this year's Hal Wootten Lecture. It is an incredible honour to do so. My staff, Elizabeth Parsons and Christina Nguyen, have been of considerable assistance to me in the preparation, particularly the PowerPoint. Liz is going to help with the PowerPoint because I can't do two things at the same time. There are many people to acknowledge tonight, but I want to start by welcoming members of Hal Wooten's family. Professor Gillian Cowlishaw, who I met tonight, and I'm very pleased to have met her, Richard Wooten, and special shout out to Caitlin Wooten, who I understand is Hal's great-granddaughter. And I'm told, or indeed she confirmed when I came today, that she completed her final HSC exam today, and it is her intention to study law, and we're all hoping that she does so at this university. So I think she deserves a round of applause. Chief Justice Bell, Justice Beach Jones, who's sitting up there somewhere to make an easy escape, I'm sure, Chief Judge Huggett, judges, practitioners, academics, students, friends, and my partner, Ernie Benton. Thank you all for attending. On Thursday, the 2nd of October, a notice went out from the Bar Association mistakenly announcing that I was giving this lecture the next day, the 3rd of October. And I was a little stressed because I had two immediate thoughts. Either those interested would turn up on Friday the 3rd of October in my absence, or I would turn up tonight without an audience. I'm happy that in the end we're all here on the same night. I commence by acknowledging the traditional owners of the land upon which we gather and pay my respects to their elders past and present. I acknowledge First Nations people's deep and continuing connection to lands, waters and culture. And I extend my respect to all First Nations people present. I pause to note that during this lecture I will be referring to the names and images of deceased First Nations people, and I do so with the utmost of respect. On a personal note, this acknowledgement must be accompanied by an acknowledgement of the Aboriginal and Torres Strait Islander people I met in Western New South Wales and the relationships and friendships that were forged there. I was a relatively young solicitor when I journeyed over the mountains, past Lithgow, through to Dubbo, and later Burke, Brewarrina, Wilcannia and Broken Hill. I was embraced with warmth, kindness and generosity. I was taken in by one particular family, sometimes referred to as their fifth daughter, and shown a great deal of support and affection. These relationships taught me a number of things, including resilience, loyalty and humour, and I'm happy to say that our friendships continue 35 years later. You may or may not be relieved to hear that this lecture will not involve a dissertation on property law, the application of the correctness standard, the ever-increasing complexity of sentencing law. Will the High Court endorse aggregate sentencing in Commonwealth cases? Who knows? Or the application of the high degree of probability test in high-risk offender applications. None of that tonight. When Andrew Lynch kindly invited me to give the lecture this year, he suggested that I might want to speak about my journey in the law, which commenced at the Western Aboriginal Legal Service in January 1990. And I decided on the title Advocacy, from Burke to Bugmy and beyond, because it seemed to be a fitting way to focus on the role of lawyers and on advocacy, while at the same time weaving in my own story. Tonight's lecture is dedicated to lawyers, those practitioners who are engaged in the noble work of representing the interests of others and, in the course of their work, calling out injustices and seeking to redress them through their advocacy. It is dedicated to those who live their lives in the law, motivated by the desire to achieve better results for those whose contact with the legal system can be disempowering and alienating, to those lawyers who, through their advocacy, seek to safeguard the rule of law. After settling on this topic, I came across a book edited by David Dixon and Andrew Lynch, which contains Hal's selected writings and speeches. And the title of the book is Living Greatly in the Law, and you would have seen it because I entered this afternoon and saw a table full of copies of that book. The book explains that the purpose of the Hal Wootten Lecture is to celebrate Hal's founding vision for the law school by inviting a speaker to, quote, discover in their lives in the law personal and social meanings and connections with the history of the times. In that way, the lectures might accumulate not a pattern for a life in the law, but examples of the varied opportunities that a life in the law can provide and the varied ways in which people respond to its challenges. That purpose resonated with me, and I hope I do it justice tonight. Before we get to Burke, circa 1990, I want to say something more generally about advocacy and lawyers. I must admit that I've always been baffled about the bad press that lawyers and judges get in Australia. The comparison to a catfish is particularly cruel. Defence lawyers get a particularly bad rap. Sometimes they're treated as though they have committed the offence themselves. Often they are portrayed as sneaky and underhanded. Judges are not immune. After all, I suppose we are a species of lawyer. Often we are accused of being out of touch, an accusation to which I will return. Now, I'm not completely naive to the flaws of some lawyers, nor do I advance a position that lawyers, all lawyers that I have encountered, have been motivated by noble principles. But I can say, hand on heart, that the overwhelming number of lawyers that I have had the privilege to know are hardworking, committed, passionate, and principled individuals. Many of them are now judges. The role of a lawyer, engaging in advocacy, often representing the interests of the most marginalised in our community, the voiceless, the disempowered, is more important than ever. So too is fighting to safeguard the rule of law. Fearless advocacy is essential to that fight and essential to the legitimacy of our legal processes. We have witnessed over the last 9 months or so events taking place in the United States which are of considerable concern. Attacks on lawyers, judges, and the rule of law are troubling. In a case of Perkins Coie and the Department of Justice, which came before the District Court for the District of Columbia, Judge Beryl Howell commenced her opinion with a reference to William Shakespeare, who penned the phrase in Henry VI, "The first thing that we do, let's kill all the lawyers." When Shakespeare's character, a rebel leader intent on becoming king, hears this suggestion, he promptly incorporates this tactic as part of his plan to assume power. The case involved a challenge to an executive order which sought to stigmatise and penalise a particular law firm and its employees due to the firm's representation of certain clients in the past and pursuing plans and taking positions with which the US president disagreed. Judge Howell noted that in a cringe-worthy twist on the theatrical phrase, "let's kill all the lawyers," the approach taken in the executive order is, "let's kill the lawyers I don't like." The opinion goes on to emphasise the importance of lawyers, their independence and courage, particularly in the face of such attacks. It demonstrates the importance of advocacy and the dangers of complacency and complicity. Living greatly in the law is a theme that Hal referred to when he gave the first of these lectures in 2008. Notwithstanding all the bad jokes and all the bad publicity, it is possible to live greatly in the law. Indeed, I would argue that it is the only way for lawyers to live in the law. And so I return to my initial contention that the role of a lawyer, of an advocate, is a noble one. Lawyers do not only have the power and capacity to make a real difference in the lives of their individual clients, but are also able to advocate for systemic change by challenging systems and processes that lead to unjust results, including, but not limited to, calling out institutionalised racism. In one of his speeches, Hal complained about his university education. He said, "Law was taught to me as essentially a closed, static system, and that lawyers thought too much in terms of cases and too little in terms of their clients. Too much in terms of the law as a closed system, and too little of its role in shaping a more just or even a more functional society." I think that lawyers in greater numbers nowadays are interested in and committed to solution-focused practices, recognising that the law does have a role in shaping a more just or even a more functional society. So as we embark on the journey to Burke, I pose these questions for your consideration. What does access to justice really mean? How do lawyers represent the interests of their clients effectively? How does our system foster dignity, engagement, strength? How do we deal with deeply entrenched trauma? How do we achieve community safety in a meaningful way? These questions are posed not only to practitioners but to judges and other decision makers. As I said earlier, judges are sometimes criticised for being out of touch. That accusation is often made in the context of criticisms about bail decisions and perceived lenient sentences. But let us just reflect for a moment on the work of judges, particularly judges of the district court and magistrates. Think about what judges do day in and day out. Judges spend hundreds of hours each year dealing with trauma, disadvantage, poverty, mental illness, drug addiction, trauma experienced by victims, searching for ways to facilitate meaningful rehabilitation and foster the protection of the community. If that does not make us experts, I don't know what will. Far from being out of touch or removed, we are in the thick of it. We have a role to play in solution-focused and problem-solving objectives because we are in the thick of it. We know what works and we know what doesn't. Of course, we are no longer advocates and there are constraints on what we can say and do. But as Hal said, every now and then there is an opportunity for a judge to give a little nudge that sends the law along the direction it ought to go. So we start our journey in Burke. And I have to pause there for a moment because I have another shout out, and that is to Lenny Pottinger. I can't see him at the moment. So Lenny is an Aboriginal man who I met, about 32 years ago, and he was the coordinator of a post-release program, yes, a post-release program 32 years ago in Dubbo. He led that program for as long as it was funded. I haven't seen him since that time, so the first time I've seen him in the last 30 years is tonight. So, hi Len. All right, for those of you who don't know Burke, it's a small town, 760 kilometres from Sydney, with a population of about 2,500 people. Roughly 30% of the population are Aboriginal and Torres Strait Islander. Interestingly, I couldn't find a specific number for the population in 1990, which is when I first went there. It is thought to have been much higher than at present because the population has been declining. Burke is on the traditional land of the Nyamba people who, along with other groups like the Barkindji, Marawari and Wangamara, have a rich history spanning over thousands of years. As with events elsewhere, the traditional owners were displaced and the Aboriginal Reserve was established in 1946. I arrived in Burke in early 1990, having left Sydney, bypassing my new home in Dubbo, picked up at the train station by the principal solicitor to be driven directly to Burke so that we could appear in court the following day. My appearance in court was not a mention or a plea. First day in court, I was given a defendant hearing for an Aboriginal man who was charged with stealing a motor vehicle. I still remember the issues in that case. The issue was identification. I'd never stepped in a courtroom before, let alone stood at a bar table. Although I had studied criminal law with a great deal of enthusiasm and commitment, it was about the only subject that I studied with a great deal of enthusiasm and commitment, I had no idea what I was doing that day. So during the hearing, I took an objection to a piece of evidence. And the magistrate said, "On what basis do you take the objection?" And I thought, who knew? You had to have a basis. You had to articulate a ground. Anyway, I felt like a rabbit in headlights, and it went something like this.
What section of the Constitution has been breached?
Section? What section? There is no one section. It's just the vibe of the thing. It's all part of it. This is what I'm getting at. That's my point. It's the vibe of it. Again, it's just the vibe of it. In summing up, it's the Constitution, its mark law, it's the vibe, and no, that's it, it's the vibe. I rest my case.
That was sensational.
Now, I share this story. It wasn't about the Constitution, obviously, but it went exactly like that. I share this story particularly with the students and entry-level solicitors in the audience. And my message to you is that everyone in this room, no matter what we have achieved or the position we now hold, has made mistakes, felt inadequate, and performed poorly at some point in their professional lives. That is not a failure. The failure is not picking yourself up off the floor, developing your skills, listening and learning, and continuing your mission. The anxiety, distress, and humiliation experienced in court in the early days, mine, not my clients', was fortunately contrasted with the security of being accepted into a small community by both First Nations and non-First Nations people. I'm glad to see the people I'm about to mention here tonight. I didn't realise they were coming. Take, for example, Esther Alvarez, the Western Aboriginal Legal Service solicitor who was living and based in Bourke, and her partner Ian Cameron, who is the local doctor. Hundreds of nights were spent sitting around their dinner table, discussing the problems facing the world and workshopping our cases. But notwithstanding this camaraderie, arriving in Western New South Wales in 1990 was a particularly confronting experience. The relationship between First Nations people and police was very poor. Much of our work at the Western Aboriginal Legal Service involved representing clients charged with offensive language, offensive behaviour, resisting and assaulting police, and violent disorder. These were the days where your clients, even where they were only charged with swearing, were routinely sentenced to terms of imprisonment. This tension, always bubbling near the surface, was complex, multidimensional, and deeply entrenched. In the late 80s and early 90s, one of the causes of considerable anger and distress was the ever-increasing number of Aboriginal deaths in police and prison custody. One of those deaths was that of Lloyd Boney, who died on 6 August 1987 in the Brewarrina police cells, found suspended at the neck by a football sock. Lloyd was 28 years old. He was arrested in a highly intoxicated state for breaching a number of bail conditions. He grew up in a household with 15 other children. He and his family lived in Brewarrina. And for those of you who don't know Brewarrina or who have never been there, it is another small town, about 100 kilometres from Bourke, with a population of approximately 1,300 people, roughly 50% of whom are First Nations. Many of the Aboriginal people who were living on the mission were moved from the Brewarrina mission to a new area situated on a treeless hill near town, which the residents called Dodge City, as a way of highlighting the racial segregation, inequality, and harshness they experienced. So the Royal Commission into Aboriginal Deaths in Custody was established in 1987, as we all know, with a mandate to investigate the deaths of 99 Aboriginal people in state and territory custody. I believe that it was Lloyd Boney's death that precipitated the establishment of the Royal Commission. Many of the families of those who died in custody believed that those deaths were homicides committed by police, and that was certainly the belief of the Boney family. In 1990, I had the incredible privilege of representing the interests of the Boney family at the Royal Commission hearing. Hal was the commissioner. The hearing was held in Brewarrina. Counsel assisting was Steve Norrish. We engaged David Buchanan to represent the family. The hearing was conducted over several days. I have a very fond memory of those three legal giants and myself, this starry-eyed young solicitor, walking from the motel to the bolo for dinner each night. Our motel was across the road from the Brewarrina fish traps, which are located in the Barwon River. They are a complex network of riverstones arranged to form ponds and channels that catch fish as they travel downstream. They are known as one of the oldest human-made structures in the world. The creation of the fish traps and the Aboriginal law governing their use helped shape the spiritual, political, social, ceremonial and trade relationships between Aboriginal groups from across the greater landscape, in addition to being an important site of food production. And here we were, staying in a motel virtually across the road, conscious of the rich and proud First Nations history, our purpose to participate in an inquiry that was going to hear about the grief, anger and suspicions of the family and the palpable tensions that existed in the community. Those tensions were in part exacerbated by the fact that following Lloyd's death and at his wake at Memorial Park in Brewarrina, the police sought to disperse the mourners, notwithstanding the fact that the family had gained the proper permission from the local council. Things escalated and several Aboriginal people were charged with various offences and were later tried in what became, or what was known as the Brewarrina riot trial. And here they are. So this is a photograph taken in Bourke Local Court in the jury box. Well, it was also Bourke District Court when it used to conduct jury trials. I can tell you, in all the time that I was living there, which was 7 years in Western New South Wales, I'd never seen an Aboriginal person in the jury box serving as a juror. This history is important in understanding the context in which the Royal Commission hearing took place. Lloyd Boney's family, even 3 years later, was gripped by grief. Their son was found dead in a police cell. Members of the family were charged with criminal offences arising from the confrontation with the police. Some of those accused were on bail not to enter the township of Brewarrina for years whilst awaiting the trial, which meant separation from family and community. There was a collective outcry for change, which led to a national reckoning. As their solicitor, it was essential that I spend time with the family and their community to build trust, to obtain instructions and genuinely represent their interests. And all of this was going on in the context of a firmly held belief by the family that Lloyd had been murdered. Although the investigations did not lead to any evidence of foul play, the significant work of the Royal Commission was to interrogate why so many First Nations people were falling foul of the justice system. This was not the purpose for which the Royal Commission had been established, but eventually it was accepted that an amendment to the National Commissioner's Terms of Reference was necessary. Hal investigated 18 deaths in New South Wales, Victoria and Tasmania and provided the regional report for these states and contributed to the final report, which was published in 1991. What began as an investigation into the immediate causes of these deaths became an inquiry into systemic issues concerning First Nations people in Australia, which included the dysfunction and disadvantage brought about by colonisation and the role racism played. Hal pointed out the debilitating impact of racism when he wrote, "Few white Australians understand how racism continues to affect Aboriginals and what an all-pervasive part of their experience it is. If there is to be a real change in the position of Aboriginals in Australian society, the non-Aboriginal community has to develop an understanding of the widespread, insidious, dehumanising and debilitating effects of racism and work to reduce its influence." Of course, there is an argument to be made that there have been improvements, although the debate around the voice referendum demonstrated that perhaps overt racism bubbles just beneath the surface, every now and then exploding into the atmosphere and contaminating everything in its way. But even accepting a decline in overt racism, we need to grapple with the existence of implicit or unconscious prejudices, the assumptions that we make about people who are different to us because we have no or little knowledge about them, no understanding of their history, their culture, their traditions. We do not value their importance and the very important lessons that they have to teach us, believing that the dominant culture is superior. I don't think we can be proud or complacent just because we have stopped telling racially pointed jokes. Instead, we have to acknowledge and address the deeper systemic factors that result in structural inequalities that all too often impact on the lives of First Nations people and communities. If we don't confront and address these issues as a community, the work done by lawyers, judges and decision makers in their individual spaces will fail to bring about systemic change. By the time of the Royal Commission, there had been a long and rich history of First Nations people's political, social and cultural activism, which sought, at least in part, to educate the rest of us about our history and about what was needed to effect real change. But I don't think we were listening. The disproportionate representation of First Nations people in custody continues to be a national crisis and is the lived experience of far too many First Nations people. This overrepresentation profoundly impacts on families and communities, as well as on the individuals who are incarcerated. If one looks at the figures, one has to reach the conclusion that we are in crisis. In 1990, 14.3% of the prison population was Aboriginal or Torres Strait Islander. In 2013, it became 27%. In 2025, it is 37%. Most troubling, if that were not troubling enough, is the increase in the number of First Nations women in custody. It's jumped from 13.5% to 33% and is currently sitting at 47%. On the 15th of October this year, the New South Wales coroner was reported as describing the spate of Indigenous deaths in custody as profoundly distressing, as New South Wales recorded the most ever deaths in custody in a single year. 12 Aboriginal and Torres Strait Islander peoples have died in New South Wales custody this year so far. The state coroner raised what she called the entrenched overrepresentation of Indigenous prisoners. She pointed out that the disproportionate rates compound the risks and vulnerabilities contributing to the rising number of deaths in custody. Taking this issue seriously means more than simply improving design and safety across correctional centres, although of course those improvements are necessary. Taking it seriously requires us to acknowledge the systemic issues that give rise to the overrepresentation of Aboriginal and Torres Strait Islander people coming before the criminal justice system and in our jails. It means listening to First Nations people about these underlying issues and the ways to address them, accepting that any programs, initiatives or reforms should be a product of genuine consultation and collaboration, a co-design model always. The failures over the last 35 years or so, since the Royal Commission's final report, are of course not the fault of the Royal Commission inquiry or the final recommendations. Writing at a time when he must have felt very frustrated, Hal wrote, "I get somewhat impatient with those who sanctimoniously point out that Indigenous incarceration rates have risen, not fallen, since the Royal Commission, as though it's the Commission's fault and they are absolved of responsibility. Our commission's expired. We went home and left it to you, those who hold power in Australian society." And of course, he was right. The responsibility lies with all of us. The important work of the Royal Commission is not limited to the 339 recommendations which address the underlying issues. The profound impact of the Royal Commission, work done by lawyers, including First Nations lawyers, is in part the narrative that the work of the Commission encouraged. Narratives are extremely important in shaping the way we conceptualise and think about the world in which we live. Real change can only come about when we alter the way we think about the world. The Royal Commission narrative focused on issues like systemic disadvantage, brought about by colonisation and institutionalised racism, and we slowly started to appreciate the central role of First Nations organisations and First Nations voices. But the recommendations of the Royal Commission, as Steve Norrish pointed out to me, were just the beginning. They need supplementation, refining and widening in particular respects. They need to be supported by meaningful discussion and consultation with First Nations communities and investment in co-design models for diversion and solution-focused practices. So this history, both personal and professional, informed the arguments, in some respects, that we made in the High Court in the case of William Bugmy. 23 years later, I appeared for Mr. Bugmy in the High Court. Now, Mr. Bugmy was born and raised in Wilcannia, and Wilcannia is 945 kilometres from Sydney, with a population of about 540 people, 62% of whom are First Nations. In 2011, the population of Wilcannia was about 600, with 77.2% First Nations. Some of you may be familiar with the facts and the issues and the grounds in the appeal. It's not necessary to go into that. I promised you a non-law lecture. But I may mention some of the facts as far as they are relevant to the topic. In 2011, Mr. Bugmy committed a very serious offence for which he was sentenced to full-time imprisonment. The sentence was increased after a successful Crown appeal, and he appealed to the High Court, where he was successful. William had a profoundly disadvantaged background. He'd experienced a background of socioeconomic deprivation. Since the age of 12, he had been placed in foster care and spent time in juvenile institutions. He was illiterate. He was exposed to very serious domestic violence and family violence during his childhood. He commenced using alcohol and drugs at the age of 13 and suffered from a range of mental health issues, including depression and schizophrenia. Perhaps the most confronting fact that we came across was at the relevant time, the life expectancy for a First Nations man living in Wilcannia was about 37 years. Mr. Bugmy was 31, just going on to 32 at the time he was sentenced to his term of 6 years imprisonment. One of the arguments that we put to the High Court is that equality before the law for a member of the First Nations community in 21st century Australia is informed by the historical context recognised in Mabo, the national reports of the Royal Commission into Aboriginal Deaths in Custody, the Bringing Them Home report, and the Little Children Are Sacred report. We argued that sentencing First Nations people should take into account the unique systemic factors brought about by a history of dispossession and colonisation. The argument was neither unique nor radical. The Supreme Court of Canada, in a decision of Ipoli, affirmed and explained its earlier decision in Gladue, requiring Canadian courts to take into account the unique circumstances of Aboriginal offenders brought about by the impact of colonisation that bear upon the sentencing process and may be relevant to the moral blameworthiness of the individual. One of those factors being the disproportionate rate of incarceration. Now, I want to pause there and share with you an amusing story because it's been heavy going for the last 10 minutes. So, I want to tell you an amusing story about an interaction that Gabby Bashir, who was my junior in the appeal, and I had with a Canadian lawyer, Jonathan Rudden. He was involved, I think, in the Gladue case, and he's the program director at the Aboriginal Legal Service in Toronto. We found out that he was in Sydney when we were preparing the submissions and made an effort to find him and ask him to come along for a chat. And he agreed. He came to my chambers and we were having a very lovely time until he turned to me and said, "Are you going to use the C word?" And I thought, what on earth is he talking about? I thought this was a credible lawyer from Canada. Anyway, it took a minute. I'm slow, but I realised that what he was talking about was the word colonisation. And we did, of course, in our written submissions, and although I'm happy to say that the appeal was successful on other grounds, the High Court, as it was then constituted, did not embrace our larger argument. But once again, what is important about the case, leaving aside the legal principle and its application in thousands of sentencing proceedings since it was handed down, is the narrative that it continued to encourage. It promoted the discussion about the continuing impact of colonisation and the importance of finding a way to meaningfully address the disproportionate rate of incarceration of our First Nations people. Advocacy in the pursuit of such goals is not limited to in-court advocacy. Now, I admit that I am a solution-focused judge, and consistent with that disposition, I want to talk to you about 3 initiatives, practical initiatives, that have come about since the decision in Bugme and as a result of those narratives. Now, there are, of course, many, many solution-focused and problem-solving courts and lists, work done by lawyers and judges, both in Australia and internationally. There are many lawyers and judges who do very good work in this space. And we have some of those judges with us tonight. Judge Hunt, who took over the Wallamar list after my departure. Judge Hopkins, who is now the presiding Wallamar judge, and Judge Beckett, who, in addition to her very busy list, started the referral list, which now sits at Parramatta. But I'm going to speak only about 3 initiatives, because I think I'm already over time, but I'm going to take the opportunity. I don't think I'll ever be asked to give the Hal Wootten speech again, so it's my night. So these are examples of the positive changes that can be made when lawyers and judges, in collaboration with stakeholders and community groups, devise ways to make change on their own patch, within the confines of existing law and precedent, using the tools available to them, often in very difficult circumstances and always without additional funding. The first is the Bugme Bar Book. Now, for those of you who are not familiar with it, it is a free evidence-based resource for lawyers and legal decision makers, as well as policy makers and other professionals. It was launched in November 2019. The Bugme Bar Book is comprised of chapters of research relating to experiences of disadvantage and deprivation. Its purpose includes, although it's not limited to, assisting practitioners in the preparation and presentation of evidence in the cases that come up before the court to establish the application of the Bugme principles. I am happy to say that the Bugme Bar Book has benefited from the support of the Centre of Criminology, Law and Justice and from the faculty through its Indigenous students. You can see some of the chapters on the screen behind me. These are only some examples of the chapters. The resource is being used nationally, and its use is not limited to criminal proceedings. Now, it's important to say something about the origins of the Bugme Bar Book because its history demonstrates the theme, the way in which lawyers can and do make a real difference through their advocacy. Rebecca McMahon, then a sole practitioner in Port Macquarie, understood the importance of an evidence-based resource, not only for the preparation of cases, but more generally in educating practitioners about how to interact with and obtain instructions from their clients, in better engaging experts to provide expert reports, and in educating decision makers. She started by relying upon research into the impact of exposure to domestic and family violence during childhood in a sentence proceedings she had before the District Court in Port Macquarie. Following that, she engaged in discussions with other interested parties and brought a number of us together to form the Bugme Bar Book Committee. That committee now is comprised of representatives from the New South Wales, ACT and Northern Territory Supreme Courts, the New South Wales District Court, Magistrates Courts, Legal Aid, Aboriginal Legal Service, the DPP, academics. Several of the committee members are First Nations judges, lawyers and experts. In the 6 years since its launch, the Bugme Bar Book has gone well beyond its original purpose of assisting practitioners and decision makers. It is a resource that informs the narrative around disadvantage and deprivation in education and policy work. Importantly, it also encourages a focus on strength-based evidence and cultural safety, cautioning against being limited to a deficit narrative, and centres the voices of First Nations practitioners and experts in the preparation of the chapters and in education. I commend to you the report on the significance of culture to wellbeing, healing and rehabilitation, which was authored by Vanessa Edwidge and Dr. Paul Gray. The report contains the emotional wellbeing framework. It's all about connection. The second initiative that in large part flowed from Bugamy, and of course I can't stand up at any podium and not speak about Walama, was the establishment of the Walama list as an Indigenous sentencing list in the New South Wales District Court. Walama was launched in January 2022. There had to be a better way of achieving justice for First Nations offenders, their families, communities and victims. A process which acknowledged the importance of cultural safety and trauma-informed practices. The Walama judge applies the same laws and precedent that apply more generally in sentence proceedings, but the approach and the practices are very different. The sentencing conversations are led by elders. The rehabilitation case plans are, in large part, overseen by community corrections and First Nations caseworkers, some from grassroots community organisations, with judicial monitoring. The objectives of Walama include the importance of centring First Nations voices, encouraging strength-based narratives, and bringing together the service providers around the Walama table. It prioritises cultural safety and trauma-informed practices and approaches. Walama recognises that working in silos is ineffective in bringing about meaningful and positive change. And you can't imagine how heartening it is to see representatives from corrective services, community corrections, justice health, and all of the other stakeholders working together in a concerted effort to bring about better results. It's a sight to behold. Walama, again, is not a unique or radical initiative. Specialist sentencing courts exist in other jurisdictions in Australia and overseas. But Walama came about because of the hard work and commitment of judges, lawyers, community organisations and stakeholders who collaborated with each other to ensure its commencement, all done without additional resources. An example, I think, of what Hal referred to as thinking outside of the box to strive for solution-focused approaches. Anyone who has participated in Walama or has observed the proceedings there will tell you about how reaffirming it is. The engagement instills dignity and respect, which encourages honest and deep engagement by the participants. That engagement increases the prospects of healing and rehabilitation, which in turn increases the prospect of compliance with court orders and better outcomes for the community at large. Importantly, as I say, the process centres the voices of First Nations people in an environment that provides respect and dignity to all, recognising the importance of cultural safety. One hears stories of Walama participants reaching the end of a 12-month program and wanting to delay their sentence so that they can remain on the program. Now, that is an extraordinary change from the usual response by clients to court proceedings. Get me out of here as quickly as you can. It's a very different approach. One of the early Walama participants wrote a poem after his experience, eloquently expressing the importance of cultural safety in the criminal justice system, and I'm going to share it with you because I have permission to do so. This is what he wrote. Cultural safety is the firelight where First Nation stories are told, where our wounds are acknowledged, not dismissed, where history is not a distant shadow but the sacred ground we walk upon. It is not just about theorising our pain, but feeling the weight of our ancestors in the silence, in the pauses between our words, in the way we sit, how we breathe, how we watch the world. Cultural safety is not a checklist, not a policy, not a footnote. It is the pulse of justice itself, the difference between a space that holds us and a space that consumes us. For far too long, the law has been a cold room where we shrink beneath its towering walls, where our tongues are foreign in our own lands, where our truths are measured against rules that were written for us, that were not written for us, only against us. The significance of cultural reports speaks of this, how trauma does not fade but accumulates, passed down like a birthright no one asked for, how our stories of survival are used against us, how the system sees our struggle as our failure, never its own. So to those who stand in the halls of power, who hold the pens that can wound or heal, cultural safety means you do not come as a saviour but as a listener. You do not assume, you do not impose, you do not reshape our truths to fit your world. Instead, you sit with us in the truth of our history. You unlearn what you thought you knew. You do not stand in front, you stand beside us until justice is not something we plead for, but something that is finally, rightfully ours. So that leads me, and I am coming to an end, that leads me to the third area that has developed over more recent years since BugMe, and that is the emphasis on solution-focused courts. Solution-focused courts are not limited to Indigenous sentencing courts. They include drug courts, domestic violence courts, the Indigenous list in the Federal Circuit and Family Court. And in Australia alone, there are about 28 different types of solution-focused courts or lists. There's also a lot to learn from our colleagues in New Zealand, Canada, and Papua New Guinea. But again, we've been pretty much working in silos, each court focusing on its own work in its own jurisdiction. And that's not a criticism, but it's an inevitable consequence of the high volume of work under difficult circumstances with little resources. But there is a real appetite amongst judges and lawyers and stakeholders who work in this space to foster a better system of connection and exchange of ideas to develop best practice. They are interested in developing ways to apply and implement some of the solution-focused practices in more mainstream courts as well. So to this end, the BugMe Bar Book, together with the New South Wales Bar Association, UTS, and New Zealand Institute of Judicial Studies, are organising a cross-jurisdictional symposium on solution-focused justice to be held in February next year and launched by the Chief Justice in the Banco Court. We have the support from the New South Wales Judicial Commission, the Australasian Institute for Judicial Administration, and the Centre for Criminology and Law and Justice. We've got presenters from across Australia, New Zealand, Canada, and Papua New Guinea. In addition to providing education and showcasing the courts, I must admit that the symposium will be very therapeutic for those who work in this space. It'll be an opportunity to hear from their colleagues, to collaborate and to share ideas and be supported and inspired by that collaboration. And again, this initiative was a vision of a lawyer, Rebecca McMahon, and this is the type of work that lawyers can and do achieve. Now, I said earlier I am a solution-focused judge, which means that I must conclude by formulating a case plan, or at least giving you some take-home points. These are the take-home points. 1, lawyers are not catfish. They undertake noble work and are at the forefront of safeguarding the rule of law. 2, access to justice is not simply about legal representation, but extends to a system of laws and procedures that are respectful and instill dignity. 3, the improvements made by solution-focused courts are a product of the initiative, hard work and commitment of judges and lawyers in consultation with community, organisations and stakeholders under challenging circumstances with little additional resources. 4, the voices of First Nations people are central to achieving systemic change and structural reform, including in developments intended to provide solution-focused approaches and diversionary programs. And 5, we must acknowledge our history and listen to and collaborate with First Nations people if there is any chance that these developments will truly benefit individuals and communities. It is fitting to end this lecture with the words of a First Nations woman, June Oscar, AO, the former Aboriginal and Torres Strait Islander Social Justice Commissioner. And she said this: "Structural reform is essential to making sure our voices are always present. I also firmly believe that our voices from the ground up are necessary in decision-making spaces to inform working practices, institutions and policies that are more innovative, caring, compassionate and enabling our peoples. To do this, we need to listen deeply with purposeful intent to our Aboriginal and Torres Strait Islander voices. Change happens. We introduce and implement reform when what we hear alters the ways in which we think about the world around us and necessitates that we act and do our work differently. Thank you.
For those who don't know me, my name's Jill Hunter. I too acknowledge the First Nations owners of this land and all First Nations people here today. I thank you for coming. It's my pleasure to thank Justice Yehia, Dina, for her all treat, no trick lecture. Yes, I have grandchildren. In doing so, I'll take a few minutes with 3 observations I wish to make. I'm going to speak about her work, but omitting her self-deprecation. First, it's notoriously known that Justice Yehia fills every after-hours moment with activities directed to the public good. This week marks the end of a typical example of Dina's commitment to guiding young and future lawyers. Every day for the past 3 weeks, she had shared morning tea during a break in trial proceedings in her chambers with 2 UNSW law students who are enrolled in the elective, the criminal trial. That's 10 students a week who she has given a personalised trial judge's perspective of the processes and the law traversed in the case before her. Another activity outside, I'm not going to give all her activities, otherwise, I know you're not here to listen to me, but it's important that we know more. Another activity outside her day job is with Justice Richard Weinstein, where they make a stunning teaching duo. Each year they guide 30 enthusiastic UNSW students on sentencing, law and practice. They teach after the court's lights have been switched off, and emblematic of Dina's style, theirs is a hands-on advocacy course that brings to the fore a set of unique qualities. I term them the Yehstein method. Their course is well detailed and structured. Nothing is done by half measures. I know this because in 2022, when she first taught the course, Dina casually described to me her sentencing checklist. But it was never a checklist, as I discovered in 2023 in year 2 of the Yehstein sentencing course, when LexisNexis published her 230-page textbook for the course. Now, I was going to proceed with a relatively detailed account of my view of the genesis of the Bug Me Bar book, which places her far more in the centre, but I don't think it's appropriate to expose her misreading of history on this occasion. That would be indeed inappropriate. What I'm going to talk about is how this is not just a resource. Listen to how the bar book changed the capacity to represent First Nations clients in the courtroom. This is taken from interviews of ALS and legal aid lawyers in a soon-to-be-published report. In that report, from the interviews, the bar book is described as invaluable, an amazing resource, impactful, one of the best resources ever. I love it. To state the obvious, no one directs such passions at a resource to be used in court. No one loves the Evidence Act. One regionally located ALS lawyer said, "I can only imagine what, in making submissions about sorry business, the response that might have been received decades ago at a regional court. Whereas I think now it's becoming part of the vernacular that you'll have a judicial officer referring to things in ways which are more culturally appropriate." One final illustration of the significance of Justice Yehia's impact. Dina referred to the Bug Me High Court ruling, although imperfect, being an important nudge. A regional ALS solicitor gives meaning to that nudge. I think that the whole premise of Bug Me deeply affects sentencing outcomes for Aboriginal people. And the reality is, if there wasn't Bug Me, if bug me the case never existed, our clients would be serving a lot more time in custody. Justice Yehia, Dina, thank you for your work towards building a more just legal system, to pressing for court structures and processes that foster dignity, engagement and strength, to building an army of next generation mini-me's. Thank you for your inspirational lecture, for being generous, kind and savvy, and for being a genuine friend to the faculty, to me, to so many people here tonight. Join me in thanking the presenter of the 2025 Hal Wootten.